Arbitration is a consensual process wherein parties to a dispute agree to submit their grievances to an impartial third party, known as an arbitrator or arbitration panel, for resolution. The arbitration process initiation. The arbitration process commences with the parties agreeing to resolve their dispute through arbitration. This agreement is typically established through one of two mechanisms. Contractual arbitration clause. Many commercial contracts contain provisions known as arbitration clauses, wherein the parties agree to submit any disputes arising under the contract to arbitration instead of litigation. These clauses outline the arbitration process, including the selection of arbitrators, governing law, and arbitration rules. Separate arbitration agreement. In cases where there is no existing arbitration clause, or when parties wish to resolve a dispute outside the scope of a contract, they may enter into a separate arbitration agreement. This agreement sets out the terms and conditions of arbitration, including the scope of disputes covered, arbitration rules, and procedural details. Arbitrator selection. Once the decision to arbitrate is made, the parties must select one or more arbitrators to preside over the dispute resolution process. Arbitrators are chosen based on their expertise, impartiality, and credibility. There are two main methods of arbitrator selection. Joint selection. Parties may mutually agree on the appointment of arbitrators. This collaborative approach ensures that both parties have confidence in the arbitrator's ability to fairly adjudicate the dispute. Appointment through arbitration institution. Alternatively, parties may appoint arbitrators through an arbitration institution or organization, such as the American Arbitration Association, AAA, or the International Chamber of Commerce, ICC. These institutions maintain rosters of qualified arbitrators and facilitate the appointment process based on the parties' preferences and the nature of the dispute. Pleadings and evidence. Once arbitrators are appointed, the parties submit their respective statements of claim and defense, along with supporting evidence, to the arbitrator. Unlike traditional litigation, where extensive discovery procedures may be employed, arbitration often features more streamlined and efficient procedures for the exchange of evidence. This limited discovery promotes efficiency and expedites the resolution of disputes. Hearings. Arbitration hearings are conducted in a less formal setting compared to court trials. Parties present their case, examine witnesses, and make arguments before the arbitrator. The hearings are typically scheduled at the convenience of the parties and the arbitrator, allowing for flexibility in the process. While formal rules of evidence may apply, arbitrators have the discretion to adopt a more relaxed approach to procedural matters, fostering a collaborative and less adversarial atmosphere. Decision. Following the conclusion of the arbitration hearings, the arbitrator renders a decision, known as an arbitral award, based on the evidence presented and applicable law. The award is final and binding on the parties, providing a conclusive resolution to the dispute. However, arbitral awards are subject to limited grounds for challenge or appeal, such as procedural irregularities or arbitrator misconduct, ensuring the integrity and fairness of the arbitration process.